Firstly, there was a bit of confusion last week because everyone seemed to suggest that, well, it's not clear whether this belongs to the Department of Correctional Services or it's an issue for the Department of Justice. This issue, who does it belong to?
Before I say anything, let me start like a good lawyer and put fine print there and a qualification. Is that I'm very happy to discuss the broad principles of Mr. Mofokeng and Mokwena's matter. However, I don't want to go into details, and especially details that involve pronouncing an opinion on specific aspects of the matter. The reason for that is, one, first and foremost, I think it would be undermining their dignity for them to be hearing on national radio me express opinions which really should be communicated directly to them. Secondly, some of the options that they have might require the Minister of Justice to make decisions, or for the Minister of Justice to advise the President to take certain decisions. And I think it would be incorrect to preempt those processes, and I think it would also be incorrect and disrespectful for the President to hear the advice of his ministers on national radio. So
in other words, this is a live matter,
yes,
and decisions are still to be made on this matter.
Exactly.
All right.
So I think just first, from our point of view, we came into contact with this matter towards the end of 2009. The Petitions Committee of the NCOP, under the leadership of the Honourable Nyambi, who was on air last week,
Monday,
contacted us, myself and the Minister of Correctional Services. We familiarized ourselves with the case, and really, I must say, we were very deeply touched by the plight of Mr. Mokwena and Mr. Mofokeng. And we went all out to get legal advice from our departments as to how we could get them out of prison as quickly as possible. Because that was our priority at that stage, to ensure that they don't spend one extra day unnecessarily in prison. The options that we had were to consider a presidential pardon. Now, there was a challenge with that, because they had submitted an application for a presidential pardon, which had become part of a process that was initiated by former President Thabo Mbeki in 2007 to deal with matters that people said were outstanding from the TRC. So as long as their application was part of that process, it would have been difficult for the President to act upon that. And I must say that process is still underway, and we can talk about the details of that later. Secondly, they could have applied for a procedure in terms of the Criminal Procedure Act, Section 327, in terms of which, if new facts in a case emerge, the Minister of Justice can refer that to the court that originally heard the matter. That's still an option, but it was going to take a long time, and it wasn't going to get them out of prison as quickly as possible. The third option was to release them on parole. There was a problem at that stage. The Correctional Services Act provided that prisoners in their situation would have had to have served, I think, at least 20 years. There was then a Constitutional Court judgment which said that actually they should be placed in the position where they would have been before the Correctional Services Act had been amended. The moment that judgment came through, the Minister of Correctional Services wasted no time in ensuring that they were released on parole. So I think just from our side to say that we are alive to their plight. We've tried and we've succeeded in getting them out of prison as quickly as possible. However, their case is a particularly complex one. They were convicted. In fact, it's ironic we're discussing this matter now in November. They were convicted on the 23rd of November 1992. So it's almost exactly 20 years ago that they were convicted. They applied for leave to appeal. It was denied. They petitioned the Chief Justice at the time. It was refused. They went to the TRC. Because they denied having committed the crime, they didn't comply with one of the basic aspects that was required for amnesty in terms of the TRC process, and that was full disclosure and admission. So they were denied amnesty. Their co-accused admitted and did receive amnesty. And I think that is the contradiction, really, that that arrested the attention of the Minister of Correctional Services and I. So I think just to say that in terms they are out now on parole. Their options in terms of clearing their names, in terms of overturning their criminal record, would be to apply to the President for pardon. That, as I've said, is part of a broader process that at one stage was interdicted by NGOs in civil society, saying that it was unfair to victims. Victims needed to be afforded the opportunity to be heard. They took that matter to the Constitutional Court. The Constitutional Court agreed. So there is a process underway in terms of soliciting inputs from victims.
Because, sorry, just on that story, because they say that they already did actually apply for pardon.
Yes, but those applications for pardon, together with hundreds, if not thousands of others, were taken and fed into this process, the so-called special dispensation process that was initiated by former President Thabo Mbeki.
Post-TRC unresolved issues of the TRC.
Yes.
And I'm going to talk about that because I would like us to take this as broad as possible. So I'll pick up on that issue a little later on. So you say, because part of what they are now asking for is that their records be expunged. What is the process there?
Well, look, just to say, and I welcome this opportunity to explain these things. There are two broad processes. The one is a presidential pardon. That is done by the President in terms of Section 84(2)(j) of the Constitution. There, the President has a very wide discretion as the head of state to grant people pardon. The President is advised by the Minister of Justice. The Minister of Justice takes certain factors into account in advising the President, but the President is not bound by that advice or by those factors. The President can grant anyone a pardon. The second process is that of expungement. Expungement is an administrative process that is done by the Director General of Justice, and it applies to people who have received sentences that don't involve imprisonment without the option of a fine, or a fine less than 20,000 rand. People in that position can apply in the prescribed form to the Department of Justice, and the Director of General of Justice will expunge their criminal records. It's really meant for those people who have committed offences that are not so serious that their whole lives should be held back by the fact that they have a criminal record, that really they should deserve a second chance. The record is then removed from the police's central criminal records registry, and they can carry on with their lives. But that is a very specific grouping of offences for which you can get expungement. Now, in the case of Mr. Mokoena and Mr. Mofokeng, I don't think expungement would be the route. They would have to go the route of either a presidential pardon or, as I've said, there is a procedure in the Criminal Procedure Act in Section 327 which allows the Minister of Justice to refer a matter back to court if there is clear and solid evidence that there's new evidence that would have affect the outcome of the matter.
But what happened again then last Monday, Deputy Minister, is that the discussion opened up a discussion about the checks and balances within the justice system to ensure that the right people are incarcerated for the right crimes. And in this particular instance, people started saying, well, is it because I got emails, people saying, well, I've also got a brother, I've also got a cousin who's been incarcerated for so many years, but actually they didn't do the crime.
Well, I think things have moved on a lot since Mr. Mokoena and Mr. Mofokeng were convicted in 1992. We now have a constitution that in terms of Section 35 guarantees the rights of accused persons. People have the right to be presumed innocent until they're proven guilty. They have the right to remain silent. They have the right not to incriminate themselves. They have the right to legal representation, either of their choice or provided by the state if they can't afford. They have the right to adduce evidence, to challenge evidence against them. And of course, if they are convicted, there are a number of checks and balances. I think firstly, where a court has passed an incorrect sentence, that court immediately, in terms of the Criminal Procedure Act, can rectify that if they realize it's wrong. Secondly, a magistrate can send a matter to a high court for review if he or she is uncertain as to whether she is convicted wrongly or rightly. Thirdly, the accused person, him or herself, can take a matter on review or appeal. There's also a provision in the Criminal Procedure Act for automatic review, where a sentence of imprisonment or a particular kind of fine is imposed on especially an unrepresented accused by a magistrate with less than 7 years' experience. That matter is automatically taken on review by the High Court. So, I mean, if an appeal to the High Court doesn't succeed, of course the person can petition or can request leave to appeal to the Supreme Court of Appeal. If that's refused, petition the President of the Supreme Court of Appeal. And if there's if the person feels that there's a constitutional matter, of course apply for access to the Constitutional Court. I think what's also important is that the nature, the extent and the quality of legal representation has improved dramatically under our democracy. We have Legal Aid South Africa that deals with about 350,000 criminal matters every year. It has a budget of 1.2 billion rand. It has about 3,000 staff members that provide legal assistance. And they don't just sit back and wait for people to come to them. Legal Aid South Africa actually goes out to those prisons where we have the highest number of awaiting trial detainees. They go, they conduct workshops, they explain legal position, they invite people to get legal representation. So I think those